Queridos, bom dia, boa tarde, boa noite, boa madrugada para os corredores. Mais um episódio internacional. E hoje eu recebo uma pessoa que eu estava querendo entrevistar já há bastante tempo. Vamos ver se eu acerto o nome aqui. Berihun Gebeye. Eu acho que esse é a pronúncia correta do nome do professor. Eu acho que a primeira parte é mais rápida, mas eu não sei fazer. Então, para não ter o perigo de eu errar muito, que nem eu fiz com o professor Andrachayo lá, que eu acho que nessa altura, quando esse episódio estiver saindo, eu acho que o episódio do professor Andrade também já deve estar disponível. Pessoal, hoje a gente vai conversar um pouco sobre constitucionalismo, mas fora da linha do continente, do hemisfério tradicional, né, da ideia tradicional ocidental de constitucionalismo. A gente traz aí o livro, que é uma baita capa. Eu apresentei, eu apresentei ele no começo, mas assim, trago aqui de novo, a capa do livro é um espetáculo do professor Gabayé, e a gente vai conversar um pouco sobre como os elementos históricos, elementos sociais, culturais, coloniais, eles vão influenciar uma criação de uma teoria própria aí para o constitucionalismo africano, que tem elementos liberais, mas também carrega elementos iliberais, como elementos, por exemplo, teocráticos. E se isso realmente pode ser visto como uma ideia de constitucionalismo. E eu acho que o episódio dialoga bem com outro que eu já tive aqui com o professor Richard Albert, eu acho que é o episódio 150, que a gente gravou sobre contra-constitucionalismo, o nome de um artigo dele, né? Counter-constitutionalism. A conversa não ficou muito longa, mas ficou realmente um pouco densa. Episódio muito bacana, eu acho que dá para aprender bastante. Aqueles temas assim que estão geralmente bem fora da casinha. E, obviamente, você que está nos escutando, não esquece de se inscrever no canal no YouTube, deixar o seu like. Se você está escutando pelo Spotify, pelo Apple Podcasts, lembra que você pode assistir pelo YouTube com legenda, porque o episódio está em inglês. Se você quiser ter uma compreensão melhor, a não sei que seu inglês aí seja muito bom, então vai lá. Mas também não deixa lá de deixar sua avaliação, deixar 5 estrelinhas lá pra gente, ajuda sem custo nenhum o canal a chegar a mais pessoas. Lembrando também que você pode ajudar a gente de outras formas mais diretas. A gente tem o Pix aqui do Ulisses Centro de Estudos Constitucionais, aqui na descrição do episódio. Tem o nosso Apoia-se, que você tem acesso antecipado aos episódios, tem acesso à nossa curadoria, recebe livros em casa aí. E é isso, se o Onze faz parte da sua vida, se o Onze tá te acompanhando aí semanalmente, se você tá se sentindo mais enriquecido intelectualmente e mais pobre comprando os livros que a gente indica por aqui, cogita dar uma ajuda pra gente, ajuda a manter o projeto de pé. Agora que eu tenho acho que uns 2 ou 3 projetos profissionais, o Onze está cada vez mais difícil de manter. Então, eu sempre conto com a ajuda de vocês e agradeço muito a quem não só escuta, mas também dá uma ajuda para a gente lá todo mês no Apoia-se. Não custa muito, é menos do que um cafezinho por semana, menos um cafezinho por mês, pessoal. E claro, não posso deixar de agradecer meus 2 patrocinadores. Primeiro, minha querida Contracorrente, editora do meu coração, que tem um dos catálogos mais sofisticados e mais maravilhosos aí do mercado editorial brasileiro. E também forneceu para a gente um cupom de desconto que está aqui na descrição do episódio, Onze Supremos 25. Quando você for comprar lá, você consegue 25% de desconto em qualquer coisa do catálogo da Contra. Fenomenal. E a gente ainda recebe comissão por isso. Amigo, maravilha. E também tem o meu querido Felipe Augusto lá, do Ouse Saber Cursos Preparatórios, que já aprovou em mais de 4, 5 mil pessoas nas maiores carreiras do direito, que a gente pode saber aí como magistratura, Ministério Público, Defensoria, Procuradorias, delegados de polícia. O Onze cria materiais e cursos de excelência e também tem cupom de desconto aqui, Onze, tá aqui na descrição do episódio, para quem quiser acessar qualquer coisa lá do acervo do Ouse Saber para encurtar a sua carreira aí rumo ao tão sonhado caso. E claro, na descrição sempre tem as referências e indicações de leitura com o link de afiliados da Amazon que converte em material pra gente, em comissão pra gente também. É isso, pessoal. Eu espero que vocês gostem do episódio de hoje. Meu nome é Davi Sobreira E esse é o Onze Supremos, um projeto do Ulisses, Centro de Estudos Constitucionais. Greetings, everyone. Today I have the honor to receive Professor Berihun Gebeye. I hope I got the correct pronunciation, Professor. And we're going to talk about this amazing piece of work here, beautiful cover done by Oxford University Press. And Professor Gebeye has done an outstanding work in his theory of African constitutionalism. Professor, before we begin, can you please introduce yourself for our listeners?
Thank you. My name is Berihun Gebeye. I'm an assistant professor in law at University College London. And I'm also an assistant, a visiting professor at the Central European University. I teach public law. I teach comparative constitutional law, comparative human rights law, and also constitution building in Africa.
Perfect. Professor, for us to begin, the first question that rises, at least among scholars, when I talked about your book, it is a skeptical question. They say, David, what is the difference of constitutionalism and a theory of African constitutionalism? Is this just a name to call attention to something that was not well explored? Is like a form to bring something that is kind of familiar to the theory of constitutionalism? Or is this something new? We have a different reading, a different approach to the principles of constitutionalism.
That's an excellent question, David. And I will start with, the standard account of constitutionalism, and I will try to show how a theory of African constitutionalism is actually different, right? So, let's start with the familiar. If you see the standard account of constitutionalism, it is related to the project of restricting arbitrary power and also ensuring limited government. And the main preoccupation of standard constitutional theory is, on the one hand, identifying the norms and institutions necessary for limited government, but on the other hand, justifying such normative and institutional choices, right? So as you know, we get these norms and institutional frameworks and their justifications from the European Enlightenment. And one of the dominant Enlightenment response to the problem of collective political life is found in the social contract tradition, where we have the idea of social contract and we have the idea of reason. And these two, out of the social contract and out of an account of reason, the state has emerged as a political form for liberty or freedom. And that the institutions of the state should be structured differently, right? So we need separation of powers. We need the idea of the rule of law, not the rule of man. We need the idea of some fundamental rights. So, here you see, I would say the three main pillars of the standard theory. So the first one is, it is a statist in its geographical conception. To think about constitutionalism, you need to have a state, right? So this is the first one. And the second one is the normative commitment of the state is liberal. It's liberal in its value commitment. And at the same time, it is complete in its self-understanding, because it depends on this idea of sovereignty. So the main question for me in writing this book is whether we should apply the standard account of constitutionalism for understanding constitutionalism in Africa, or whether we should develop a constitutional theory specifically from and for constitutionalism in Africa. And as you may have guessed, I chose the second option, and discovered that there is actually something called African constitutionalism. And this African constitutionalism, I call it syncretic constitutionalism. And here is the difference between African constitutionalism and the standard account. And my point of departure in thinking about constitutionalism, in the African context, was to move away from these abstract ideas of thinking about constitutional institutions, constitutional arrangements, and constitutional values, to look at actually the concrete practice of constitutionalism. And to do this, I have to navigate what constitutionalism looks like in pre-colonial Africa. And I have to consider how colonialism impacted pre-colonial constitutionalism, and how independence or how constitutionalism looks like after the end of formal colonialism. So because of this concrete departure, African constitutionalism is different from the standard account, at least in three major ways. The first one is it operates within what I call a syncretic state. And we will be talking about it a bit more later. But a syncretic state is a bit different from, the kind of state we have in Europe or in the US, for example, right? It is basically a state created by law. It is a legal state. To this extent, it's a child, not a parent of law, right? So because it's a child of law, it is open to accommodating, values below and even beyond the state, right? It's open. So this is the first major difference. And the second major difference between African constitutionalism and the standard account is the state is committed to both liberal values, constitutional rights, democracy, limited government, but at the same time, it's also committed to non-liberal ways of being rooted in culture, religion, tradition, right? So it has its dual commitment. And the final one is obviously, the state doesn't consider itself complete, right? So the implication of this is that the constitution of constitutional democracy depends upon actually the openness of the state rather than closure, right? So this means that it has to draw normative and institutional resources from, customary political orderings, regional and sub-regional formations, including international law. And these features will be evident as we progress with our discussion, but I would say I think these are the major differences that I see.
I think one of the first parts that caught my ear as you were speaking is the feature that constitutionalism. There is an excellent book here by the University of São Paulo professor Gilberto Bericovitch. In English would be called Sovereignty and Constitution, a critique for the constitutional theory, the constitutionalism theory. And he explains that when we got the birth of constitutionalism as we know it, as the contemporary version, the modern version, we got the constitutionalism rising with the idea of the liberal revolutions that bring us fundamental rights, rule of law, and constitutionalism. And they are what we can call in a Habermasian theory co-original. They're codependent on each other. But the problem is that constitutionalism, in his view, tames, domesticates the power of the constituent power. So it is an ideological view, but it disguises itself as neutral to tame the state through liberal principles. And I remember another article from Professor Richard Albert, Counter-Constitutionalism, in which he explains how different parts of the world has implemented the idea of constitutionalism in non-liberal versions. And to wrap this thought up, it is, I think, part of what scholars in constitutional transplants say is that when we export ideas from another parts of the world, they come, when they are internalizing in other parts, they come through a filter. So a cultural filter, an economical filter, a social filter. And I think what you have described is African constitutional theory, if I got it right. African constitutional theory is constitutionalism, but its features have come through a filter, and as we're going to discuss, they have come like what we can see, for example, in some parts of Asian constitutionalism. We're gonna have some parts that seem oxymorons. For example, what we call in some parts of Europe of illiberal constitutionalism, not in the same sense, of course. Did I get it right?
Yeah, you are absolutely right. When we are trying to understand constitutionalism, as it works, and obviously there may be, I think one of the, we will probably discuss it later. So it has a contingent role, right? So the theory could foster democratic constitutionalism, but it may also foster authoritarianism. So the task for us, I think, as scholars and as educators, is try to understand what is going on as a matter of fact, and identify the conditions that are conducive to democratic constitutionalism. I think to this extent, you are pointing to the right direction.
Going through a bit of history now. In your book, you talk about the Berlin Conference, which was held in the late 19th century. And you identify this conference as the turning point in the genealogy of African constitutionalism. Which elements of that treaty resonate in which are the elements, and which of those still resonate in contemporary Africa?
This is a very excellent question, and in many ways goes to the core of what I try to achieve in the book. The theory I advance in the book is grounded in concrete, accumulated human experiences, and also collective human desires, rather than in abstract concepts such as the state of nature, what is reason, rationality, and all that. Then the big question is, where to start in this vastness of time and human experience at a continental level. So the Berlin Africa Conference of 1884-85, as you rightly pointed out, is a turning point. And I will explain why in a moment, but this gave me a reference frame to work out, as I said earlier, what constitutionalism actually looked like in pre-colonial Africa, whether there was such a thing as constitutionalism, whether this idea is a European import or export, as you like, and how colonialism interacted with pre-colonial indigenous political formations, right? So to this extent, it was an important reference frame. And even in a meaningful way, I think the Berlin Africa Conference, if I may say, is, forms part of the genesis of the constitutional form and the constitutional law, that we see in Africa. So to this extent, it goes, I think if you see the Bible, the Genesis, the earth was formless and empty, and darkness was over the surface of the deep, and all that. The general act of the Berlin Conference shares a similar sentiment to this verse, I think. And this is for the following reason. Colonial powers assembled in Berlin created a constitutional form and law for the African continent out of nothing, right? And they superimposed new territories, they separated people, they grouped people together, forming new people. They established new governments, new kinds of sovereignties over indigenous constitutional arrangements.
Without
So
any input from the African people, we must say, right?
No, even if you see the participants of the Berlin Africa Conference, actually the United States was an observer. And so there were a few states, I think the US, Sweden, I'm not quite sure, but there were a few other states who were an observer to the Berlin Conference, but the parties to this conference were European powers.
No input whatsoever from the colonized that were having this imposition.
No. So basically,
as we can expect it.
Yeah. So basically, they assembled in Berlin. I think Bismarck organized the conference, and they adopted a charter, which is an international treaty that binds them in their engagement with the African continent. So they draw basically the map of Africa that we see today. So to that extent, it fundamentally altered the kind of political, people's political structure and action. And as you see, we have 54 states today, and many of them are deeply rooted in this in the Berlin legacy. So it's a very defining moment for constitutional development on the African continent.
Moving forward, there are two very, I think, core concepts in your book, and I would like you to please explain them and develop them a bit. The first one is legal centralism, and the other one is legal pluralism. And to what extent does these two approaches fail to capture the Africa's constitutional reality?
Sure. So legal centralism is associated with the development of the modern state. And the state, and it has two aspects. So the first thing is, there's a story the state tells itself that, I am the sovereign authority on this land and on these people. So the law of the state is supreme over all other laws. But the other part of legal centralism is the idea that law is connected with the state. Law gets its normativity by its association with the state. In the 1980s, I think John Griffiths, in an influential article titled "What is Legal Pluralism?" he explained the idea and ideology of legal centralism, basically, concisely. And he says that according to legal centralism, law is and should be the law of the state, uniform for all persons, exclusive of all other laws, and are administered by a single set of state institutions. So basically, this is the idea and ideology related to the modern state. Legal pluralism, on the other hand, is posited in sharp contrast with legal centralism. And it claims that law is neither the exclusive domain of the state, nor is the state law superior actually to non-state law. And multiple legal orders or laws could exist within a social field. Concretely, in the African context, this refers to the existence and application of state law, customary law, Islamic law, or religious law, right? So this is the context. And as you could see, both these ideas or frameworks are relevant in some sense, but they have also deficiencies. I think their deficiencies has to do with their understanding of the state, how the state works, how the government actually functions, and how people lead, in different parts of the country.
Professor.
Yeah.
Four other concepts they are present in your book. You describe them as intertwined stands: international law, European colonial laws, African indigenous laws, and the constitutional liberal norms. How does these four elements dialogue or conflict with each other in your reading?
So basically, the four points you mentioned constitute what I call the African constitutional matrix, right? You have international law, you have colonially inherited legal system, customary laws, and of course you have liberal democratic constitutionalism. And these are the matrix that actually structure institutions, values, and ways of decision making. So if you see international law, for example, on the one hand, it outlines what is politically possible and constitutionally achievable. And at the same time, it also offers the legal security guarantees for the practice of constitutionalism. Because, international law recognizes state sovereignty. But at the same time, African states have to constitute self-determination within the boundaries of the colonial state, right? So it has its own advantages and also limitations. So this is the first aspect. And the second aspect is related to, the legal system. Actually, what is the place of the colonially inherited legal system on constitutionalism? There is a lot of continuity, actually. So what has changed was a constitutional state was introduced on top of this colonially on top of the colonial administrative state, right? So there is the legal system is functional, of course, subject to the constitution. But the implication of this is that the executive branch and the bureaucracy were beneficiaries. They have accumulated almost untamed political power based on this legal system. And the constitutions didn't do much. To this extent, this is also constitutionally relevant. And of course, the third aspect is you have customary laws. These are not simply laws that govern, personal issues, but the customary institutions actually retain a significant customary public power, right? So public power is dispersed, and those were held by traditional institutions. So it's not simply the domain of modern administrators or institutions, right? So, and the final one is you have democratic constitutionalism, you have separation of powers, constitutional institutions. So they are functioning within the dynamics of these four pillars. And then, the constitutional practice may go in one or another direction, but all of them are coherently tied by the written constitution in syncretic ways and processes.
Turning to our beloved comparative constitutional law. Now let's go to some examples, practical examples. In your book, I would like to ask you what lessons emerge from, for example, juxtaposing Nigeria's centralized federalism, Ethiopia's ethnic federalism, and South Africa's cooperative government. What can we extract of knowledge from these intertwined connections?
So, I think this is a very good question. So, what I did was, I have this framework and then try to test these with related to federalism, executive power, and constitutional rights. So related to federalism, many African states are not actually, they are not interested in the federal idea, right? But states such as Nigeria, Ethiopia, and South Africa, so they adopted the idea of federalism, meaning they adopted the forms of federalism, such as, for example, you need self-rule and shared rule, you need judicial review, you need a written constitution, you need vertical separation of powers, right? So to this extent, there is commonality with other federal states, such as Germany or the US or Brazil. But they use federalism actually to accommodate diversity and to maintain territorial integrity. That's the goal of federalism, right? Because the goal is accommodation of diversity and maintaining territorial integrity, federalism may not have a necessary connection with constitutionalism or with liberal democracy, right? In Nigeria, you see, military leaders steering the federal system. Originally, there were 3 states. Now, we have 36. In Ethiopia, it was a unitary state. Now it's an ethnic federation. And if you see the trajectory of federalism in Ethiopia and Nigeria, it has to do with the accommodation of diversity. And the implication of this is that we may not be able to attribute much of the constitutional or democratic deficits that we see in these countries to federalism, because that's not its task. The story related to South Africa is a bit different. And it has to do with their, history in many ways, and also political organizations, the political party system. So in South Africa, they have a unified political party system under the African National Congress. In Ethiopia, it was divided. Political parties were based on ethnic groups, basically. The same in Nigeria. So I think South Africa introduced cooperative government as a peace deal to ratify their post-apartheid constitution, because there were some political actors who demanded federalism. But the African National Congress actually thought federalism may be a challenge for South African transformation. So I think one of the takeaways of legal syncretism related to federalism is that the instrumentalization of federalism to other, goals, and to constitute some kind of constitutional order that takes into account the interests of many groups.
Turning to the executive powers, how does this concentration or dispersion of power dialogues with your theory of legal syncretism, for example? In these three particular countries, of course. Sorry.
Yeah, sure. So the executive, as I mentioned, one of the, if you see the design of the executive branch and the constitutional powers they have under African constitutions, you would notice that African executives are actually constitutionally strong. They can do many things constitutionally. And the reason for that was, on the one hand, they thought that we need a strong executive branch, partly because it was alleged to be compatible with the African philosophy of government, which centralizes power. And if you see chapter 2 of my book, I investigated different political formations in pre-colonial Africa and didn't find a uniform system that gives much political power to, one individual. What you see is actually decision by consensus, participation, so on and so forth. But they invoke this African idea of centralized power to give more power to the executive branch. But at the same time, they also want to retain actually the logic of the colonial governor. So one of the legacies of colonialism in Africa is the practice of the colonial governor. And this is the person who has legislative, executive, and judicial power. And they are only accountable to people in London or in Paris or in Lisbon, so on and so forth, right? They are not accountable to the African people. They are accountable for the metropole. So they try to maintain that. And in this process, they chose the presidential system, of course, and parliamentary systems with the African continent are actually very few. But what I show in the book is, regardless of the regime type, presidential, parliamentary, or hybrid, legal syncretism is used to concentrate executive power on the president or the prime minister. Nigeria is a fully presidential system. Ethiopia is a parliamentary system, one of the few countries. But if you see the power of the prime minister and the power of the president in these two countries, it's the same, right? So in terms of institutional choice, sometimes you may not be able to accumulate power through a presidential system, and then they go to, then they opt for a parliamentary system to accumulate power. So I think the difference here is South Africa is different. So in Nigeria and Ethiopia, you see, these constitutions or these leaders or political elites try to consolidate political power by selectively choosing the power enabling aspects from different, institutional arrangements. What you see in South Africa is opposite, right? So they try to combine different legal ideas, but the idea is actually to constrain executive power. So here, like federalism, the executive could use legal syncretism to consolidate their power, but they could also use to structure it in a limited way. So to this extent, it has a contingent role for democracy or authoritarianism.
Still on the thesis of legal syncretism, there is another example in your book. There are several, but another one is regarding women's rights that kind of shows this fusion of liberal equality norms to customary religious practices. In your reading, which of the court cases best illustrate this syncretic laboratory that you describe?
So I think, many of the cases that I use are instances of syncretism. And the answer to your question, what is the best, actually depends upon whom you ask. But, my thesis is that regardless of our particular preferences, for example, as a liberal, as a Muslim, as a woman, as a person who deeply believes in customary traditions, we may have different preferences, but my argument is that syncretism actually captures the constitutional practice, and we can actually achieve the desired outcome through it. And I'll give you two examples here. So the first one is the Amina Lawal case, which is a famous case in Nigeria. So what happened in the Amina Lawal case was that she was charged with the crime of adultery, and death by stoning is a punishment under Islamic law. Here, there are two issues. First, issues related to equality, and second, issues related to the nature of the punishment, right? Islamic law is applicable in Nigeria. So this is a background. So the man whom Lawal alleged to have committed adultery with her was not actually prosecuted due to lack of evidence, while her pregnancy was the single concrete evidence for the crime. Here you see issues of equality or inequality. And the lower Sharia court sentenced Lawal to death by stoning, but the Sharia Court of Appeal set her free on procedural grounds. I think this is key. So the Sharia Court of Appeal set her free on procedural grounds. And we should also remember that there were a huge campaign, both inside and outside Nigeria, related to the decision against the lower Sharia court. So at the end, as I said, I have to account, or we have to account for, the role of civil society, and also the role of innovation, procedural innovation. So as I said, the outcome, meaning, she's set free, is compatible with the Nigerian constitutional system that recognizes both Islamic law and liberal human rights. And you see that the procedural innovation of the Sharia Court of Appeal in quashing the lower court decision without making it a contest between Islam and liberalism. And I think this is the strength of this approach. It's not about, this is superior to the other. Even within our system, we are not going to do this. So I think this is one instance where syncretism is at play. And the other important case or interesting case is from South Africa, where you see Shilumbana, another famous case. It's also an instance of syncretism, and you will tell me which one is a good example of syncretism. So I will leave it to you. But what happened in Shilumbana is she was not allowed to succeed her father as a traditional chief, despite being the eldest child, as women were not allowed to be, traditional leaders under their customary law. So because of this, her father's brother become the leader of the community. And then following the post-apartheid democratic transition, the traditional authorities in that community changed the law, enabling women to be traditional leaders. So the question then is, and the traditional community made Shulumbana to succeed her uncle, right? But the child of Richard Noamtiwa challenges the decision because, his father was the traditional leader and he's the eldest son and he should succeed his father.
And we are seeing Game of Thrones here rising.
Exactly. It's exactly like, like that. And he has a good legal case according to the customary law, that's but actually the High Court and the Supreme Court of Appeal in South Africa agreed with him. So the traditional authorities acted illegally in making Shulumbana the chief of the community. That violates customary law. But the Constitutional Court reversed the decision, saying that we should defer to the traditional community, especially when it advances the rights of women or equality or dignity in line with our constitution. Here you see a tension between women's equality and the idea of the rule of law. So I think in both instances, both Amina Lawal and Shulumbana, we got the desired result, which protects women's equality and dignity. And one of the advantages of syncretism is that it multiplies the spaces for rights claims and contestation. Yeah.
Still on Nigeria and the idea of legal syncretism. Nigeria, as you describe, has a two model, constitutional theocracy and a democratic order, so to speak. And you call this, I think, as a constitutional jurisgenesis. Within this context, I may ask, what are the safeguards that prevent one model from devouring the other?
So I think this is a very big question. So first we need to understand how this system came about. I think part of the answer is found there. So if you see how this system came about, it was through constitutional democratic means or processes. And the Sharia implementing status basically make a case for Sharia based on federalism, based on religious freedom, and based on the power of status to make laws as they see fit. So the argument was actually made that constitutional theocracy, a part of Sharia within a broader, constitutional democracy, they thought was possible and achievable within the Nigerian constitutional order, right? So one, it was, and then it is elected officials actually advanced this idea. It's not, it was not the idea of radical, Muslims like Boko Haram. So these are people elected by the people, and it was a result of a democratic election, right? People start electing governors, and governors making, introduce Sharia following the legal procedure and constitutional rule. So to this extent, because these both parties work within this scheme, there are more reasons to collaborate and to stay within their own lane. But the other is, in Nigeria is a centralized federation, right? So there is only one Nigeria police force in the federation. So this status actually depend on the Nigeria police force for the enforcement of their Sharia criminal justice systems. They get budget from the federal government. And they are also subject to the Nigerian Federal Supreme Court, right? There's a unitary court system. There are different court systems, but there is also a Nigerian, a uniform judicial system. But I think most importantly, syncretism encourages complementarity. So Sharia implementing states try to modify and adjust their views so that they could work with the federal government. And the federal government is bigger, and they have a number of other priorities, right? So they have to work on issues of common interest, and that is a matter of politics, right? I think politics in significant ways keep these two systems coexist. So there is law, but at the same time, there's also politics and power.
For us to wrap this up, my final question is, how does your approach on African constitutionalism, a theory of African constitutionalism, dialogues and engages with other proposals, such as, for example, decolonial constitutionalism, which also seeks to reconcile this idea of legal pluralism and universal rights?
So in significant ways, my preoccupation was try to develop a constitutional theory from and for Africa, right? So I was not trying to engage in decolonization, so on and so forth. But I think you could also think about the book as an approach of decolonizing constitutional theory. So as a theory, it goes beyond this Manichaean view of the colonizer and the colonized, and resists some parochial or even universal ideas of good constitutional government. So, we have seen related to constitutional rights, the executive branch, federalism. So what are we trying to achieve here, right? So it faces concrete, political and constitutional issues. And so the aim of the theory that I advance in the book is try to understand the complex, messy, and also intertwined nature of contemporary constitutional governance at various levels, at the local, national, regional, and even global levels. They all intersect. And so my aim was, how could we respond to those intersections, and how can we design institutions, values, and ways of decision making so that we could, advance freedom for people who are oppressed in many ways. So to this extent, you could see that it's an approach to decolonizing constitutional theory, and some of its insights may be valuable in other parts of the world with a colonial past, such as Latin America or Asia, because many of the issues in many post-colonial contexts or societies, are similar. There is a power hierarchy under the international level. There are issues of recognizing indigenous communities, so on and so forth. So, I would say there are at least 3 ways in which the theory I advance in the book may be relevant to other societies such as Latin America, right? So these are, it's a hypothesis. So the first is it affirms the agency of people, right? And including indigenous people. So when we do some work of decolonization, so people have some agency, right? So they can choose, they can reject, they can, accept and modify. So the theory recognizes and affirms people's agency. And second, it's also open, both procedurally and normatively to, deeply rooted multiculturalism. In Brazil, we have a liberal democratic constitutional system, but we have also indigenous people. So the question is, how are we to go about accommodating or engaging with indigenous peoples within our democratic constitutional framework? Should we, how that should work out? I think here, syncretism offers an interesting point because, it helps us, many societies to navigate, how to deal with, diversity. So, or what is the best way to go about accommodating or dealing with, different legal and also political systems. So to this extent, is deeply committed to deeply rooted multiculturalism, and it may be important to address some issues of indigenous peoples. And of course, I think the third and the final one is it encourages dialogue and discussion, basically, right? It advances the ideals of public reason at many forms and many levels, right? We could advance human rights within an indigenous legal system, but we could also expose the indigenous legal system to other values. And we could also expose this, liberal democratic constitutional system to other ways of conceiving rights and values. So what what emerges from this contestation and dialogue is what people really want in those particular places and particular times.
Professor, thank you for this very enlightening conversation, exposition, above all. I think I just made some interventions. I think this brings a lot to the table. I think the past few decades, I think above all the last decade, have seen the rise in comparative constitutional law of studies like yours that not decolonize, but brings the idea that constitutionalism is not just what was seen in the Western Hemisphere. And I think you bring some very interesting, important insights for us to dialogue with. And I hope for our listeners that have come this far and have watched everything, it has been as joyful and enlightening to you as it was for me to listen to Professor Gebeye here. Professor, thank you so much, and I hope we can talk again in the future.
Thank you so much, David, for this wonderful talk.
For those who keep continue hearing us, we see each other in the next week, and bye-bye.